Hi, and welcome again to the Trustcast show. And we're really happy to have with us today Paul Cannon from Texas. Paul, welcome to the show.
Thank you so much for having me, Zane.
Paul guest drummed in an Austin band whose singer went on to front Spoon before trading in the stage for a courtroom years ago. And he since tried more than 50 cases to verdict. Paul, what made you trade in the drum set and your illustrious career there for the law?
Well, yeah, it was kind of funny. I had kind of had two dreams growing up, and one was to be playing a rock and roll band, and one was to be a lawyer. I actually met the singer of Spoon. I've known him since third grade. He and I grew up together, and we played in a band in high school together. We got to college, we played in a band there, and end of about I rushed through undergraduate in 3 years. When I got ready to graduate, I kind of had a choice. We could either keep pursuing this dream, or I could go to law school. And I kind of gave myself this time frame. I said, if I can get a good recording contract landed in 3 years, I'll go that route. If not, I'm going on to law school. I'm not going to give up law school for the hope. And we had been kind of talking with a company, and they were not making a great offer or anything to us, and that was about the only thing we had at the time. And kind of went, sorry guys, I'm going on to law school. And so I went off, and the band kind of broke up, and he went his way, and more power to him. He's still touring the world.
Wow. So you turned down appellate work to do trial law exclusively. What did contract law lack that trial law attracted you to?
um I'm not, so I started out at Simmons and Fletcher doing personal injury from the get-go. As far as work
Okay.
goes, I had an when I was in law school, I had the opportunity to be an appellate brief writer, and for it was kind of considered a big prestigious thing at our school. But I looked at it and went, I don't want to sit in a library somewhere and write briefs all day long. I want to do the fun part. I want to be the one who gets up and does all the arguing. And they said, well, we got people who do the arguing. We need somebody who can write briefs. And I had gotten a really high grade in my first writing course, and I just kind of went, sorry, that's not the road I want to go. And so I walked the other way on that one.
So you went from clerk to associate to partner to managing partner in 2020. Do I have that right?
Correct, correct.
What was the moment that it stopped being someone else's firm?
It's kind of funny. It was a long journey. I was supposed to be a temporary employee, and next thing you know, I went all the way up. And I guess it was really in 2020 when the existing senior partner passed away. We were actually at that point negotiating a new partnership between him, me, and the my current two partners. And it just so happened, a freak incident. We lost our two senior partners, one in 2019, the other in 2020, and suddenly we all looked at each other and went, "It's our firm now. Well, let's run with it." We had kind of been doing a lot. I mean, I had been already doing a lot of the management stuff early on. The existing managing partner had kind of started working with me, teaching me the ropes, and showing me where he wanted me to go to eventually take it over. So it wasn't that big of a leap, but it was definitely an unexpected leap in 2020.
So as a managing partner, how many attorneys you have at your firm?
There's just the three of us. We kind of have kept it strictly where we want it to be partners handling the cases, not some new baby associate that may or may not know what they're doing. And so the three of us as partners are there, and then we have a large staff that helps us be able to focus on handling all the cases ourselves.
Okay. Well, that was my next question: is how much time do you spend managing a bunch of it? What would you say, baby attorneys, versus? But you answered that. So okay, I got rapid fire. Myth or fact? A truck wreck is just a car wreck with bigger cars.
That's definitely a myth. The truck wreck has got so much more to it than a typical car accident does.
Okay, we can get into that. If the police report blames me, my case is over.
That's not necessarily true. I've actually taken cases on before where the police report put my client at fault, but happened to be looking at it, looked into the details, and went, "No, that's not really how the law works in this situation." And we've had a couple of them that I can think of off the top of my head where we reversed the decisions that were in the police report. It's rare, but it
Okay.
happens.
Myth or fact? I can't recover anything if I was partly at fault in
That's
Texas.
not true at all. That's a myth. As long as you're less than 50% at fault in Texas, or 50% at fault, or as long as you are at least 50% or less, I should say, in Texas, you can still make a recovery. It just affects how much you can make a recovery for.
Okay. Uh, myth or fact? Only the driver can be held responsible, not the trucking company.
That's definitely a myth. The trucking company often is the one who's really the negligent party in this situation. Sometimes they don't train the drivers correctly. Sometimes they don't provide them with the proper inspection and equipment. A lot of times it's the trucking company more than it is the driver.
Here's a different one. Myth or fact? Homeowners insurance won't cover a dog bite.
That's a myth. Let me start that answer over. So, homeowners insurance, it could be myth or fact because a lot of homeowners insurance policies will exclude dogs. The standard policy covers anything you could be liable for, but a lot of them will have exclusions in there. Some of them exclude certain breeds, some of them exclude just dogs incidents in general, and then some of them provide complete coverage. You just don't know until you get it.
Okay, I'm not out of weird questions yet. So you're not out of the woods. Okay. So if an 18-wheeler hits me on I-45 tomorrow, what's the very first thing I do and what's the thing everybody does that hurts them?
Well, the very first thing you should do is obviously seek medical care, contact the police, make sure that the scene is well documented, and that your rights are being looked out for. Contacting a lawyer soon after that is very wise if there are substantial injuries because what a lot of people don't realize is the 18 wheelers have entire teams whose job is to get out there as soon as possible and start analyzing the facts and figuring out how they're going to spin it in their favor. And the last thing on earth you want to do is give them the chance to spin the whole story instead of you being able to present the truth. And so that's the mistake most people make is not getting their own lawyers involved early enough.
So what evidence disappears the fastest after a truck crash and how fast is fast?
um, so after a truck crash, probably the most evidence that can disappear if you're not careful is just evidence of things such as whether or not there there was anything in the cab that would have indicated was the driver himself on any kind of no sleep aids or anything that might have impaired or affected his driving ability otherwise.
So talk a little bit about preservation letters in these kinds of crashes.
So, a preservation of evidence letter is extremely important to send out, particularly in an 18-wheeler accident. You want to send something out because there's a lot of documentation out there that is required by federal law for them to keep. There is things like the what we call the black box, which is the uh, data monitoring unit that will track the movement of the truck and things like that. That evidence can be critical in proving where the truck was going, how the truck moved, what speed it was going, how he reacted to certain things. Preservation of evidence letters in these type of cases are going to be very specific and say we want a set timeline of the past preserved so that we can see what the entire trip looked like, how long was he really on the road for, how fatigued may he be, that sort of thing. But we also want to preserve any evidence that would show otherwise. Did he do the proper inspection? Was there anything noted in the inspections that was not properly cared for, or taken care of by the either the company or himself in the pre-trip or the post-trip inspections?
So if you don't get out a preservation letter or you don't or you're not timely in getting out a preservation letter, um, it, do you just expect that evidence is going to be destroyed or maybe intentionally or unintentionally?
Well, it's It can be both unintentionally as well as intentionally destroyed. And I mean, the reality is you just don't know what's going to happen to it if you don't send that letter out. The letter is what stops it, hopefully, from occurring, and puts them on notice so that if they were to alter or destruct evidence that you requested be preserved, you now have an avenue to come back and say, you were on notice. We wanted this information. It's relevant to a claim, and you can potentially sanction them depending on what jurisdiction you're in. You may even have an independent cause of action against them for not taking steps to preserve that evidence.
So how do you, I was always curious about this. So you send out a preservation letter and then how do you ensure, um, that they're actually preserving the evidence? I mean, what's the steps that you go through to make sure that that actually happens? Because it seems like a difficult task.
Well, yes, it very well can be. So you send out the preservation of evidence letter to the other side, and the reality of it is you don't know for certain until you start subpoenaing records, subpoenaing video evidence, things like that that you know is supposed to be there. And when they can't provide you with the data from the black box, or where they can't provide you with the records that they were required by federal law to keep, then you now have the ability to say, wait a minute, we know something should be here that isn't. And you you then can start taking the depositions of the various individuals who have a duty or obligation to keep that evidence, and you start literally just digging until you figure out who was the one that last saw it and what happened to it. And then at that point, when you've documented your case that they failed to preserve something they were supposed to, that's when you then turn and you go to the court and say, we want sanctions, we want a penalty imposed, we want, justice served because of what was not done.
So, what's a bifurcated trial, and what did HB 19 actually take away from injured people?
Well, so bifurcated trials are basically you separate the evidentiary phase of the case so that the jury makes a decision, first of all, as to whether or not there is legal liability, and then you have a second phase that has to do with whether or not you can assess punitive damages or other damages. And when you bifurcate a trial, you're basically saying we're going to do this in two separate phases, which is it is it means that some of the most egregious evidence that might make a jury realize this company needs to have action taken against it won't even be heard until they've determined that the driver of the truck himself was actually negligent, was actually liable for it, and then they can start to hear the evidence of and the punishment phase for the rest of it.
So, how does that affect the process? So, I mean, because if you're not looking at the thing in full context, I guess the thought process is we're going to prejudice the jury or the judge or whatever, if we look at this in full context, because this context over here really has nothing to do with the decision over here. But how does that work in practice?
Well, it can make it very difficult because the evidence that is relevant, that really makes a jury understand why there's a need for something to be done, may be completely withheld from them, and then they're sitting back going, I don't understand what the big deal is. And it's a lot easier to look at simple acts and go, wait, was this person really negligent, when you're only getting a small view of certain events versus the big picture.
Can you give me an example? I mean, I'm picturing in my mind, I can see this happening, but can you give an example so the audience can understand what you're talking about?
Trying to think of an example off the top of my head. Hang on just a second. I'm going to see if I can look at stuff real quick.
See, this is as a testimony. I don't give these questions in advance. There's no prep. You just get the questions, and so this is This is good.
Well, so for example, in a case where you're looking at what is the negligence, I think one of the most recent cases that has happened out there um, was the Werner trucking case that went up on appeal, and there's a lot of different decisions made about it. But it was a situation where there were facts that a truck is going down the road, the car hits black ice, collides with the truck, the people in the vehicle are severely injured. And in a case like that, the question becomes, okay, was the truck driver negligent? And when you're looking at just the facts of the accident, what you see is his truck driver is driving down the road, someone hits black ice, they run on the truck. Well, okay, that sounds to the average individual, hey, you're talking about this is just the individual's fault. They hit black ice or whatever. When you look at the totality of the circumstances, though, there the evidence that you realize that's very important is there are rules, there are specific guidelines in the books that say, hey, um, somebody who is driving a 18 wheeler and has an alert that there's black ice really needs to slow down and get off the road. They need to be driving way under the speed limit till they can get somewhere safe, and they need to get off the road. Why? Because other vehicles hit that black ice. They can't control themselves. And an 18 wheeler moving at a high speed is a dangerous vehicle just by being on the road at that point. And so in that particular case, there's a lot of facts that came out in that case that may get bifurcated in this type of a case, um, where it's important to know that, hey, wait a minute, the 18 wheeler company could have done something different by training the driver not to be on the road in these conditions or this situation.
So
And
that
so when
that
you
was a
start talking
$90
about
million
bifurcating,
verdict.
it's the best example I can come up with off the top of my head. But when you bifurcate, you stop and say, we're going to take certain facts away from the negligence, and focus just on the driver's negligence and not on the 18 wheeler company's negligence and or other negligence that may have been involved.
Yeah, that's a good example. So on that was a $90 million verdict that was reversed, and now what do you have to prove that you didn't have to prove before?
Well, they're going to have to go probably directly and prove that the driver had direct negligence without being able to utilize a lot of the things that they utilize. In that particular case, the appeal itself was more focused on the damages and the way that the damages were presented. Um, and the end result of that is going to change how they can prove up what the ultimate injuries were for a little girl that was very severely injured, if I recall right, as well as another child that was killed in that crash. And they basically came in and said, look, we're not going to allow you to do the technique that trial lawyers have used in the past called anchoring, which is where you basically say, hey, this person's life was the same value as a Picasso or something like that. They're going to make you come up with some sort of way of saying what is the real monetary calculation of the person's pain and suffering, which is extremely difficult to come up with a number value for.
It almost seems like an immoral. I'm just it's my own personal. It seems like an immoral question to have to pose, but I guess I don't know how else you do it. So Senate bills 30 and 39 failed in 2025, and supporters are coming back in January 2027, as I understand. What do you want lawmakers to understand before that session?
Oh Lord.
See, I told you there's no inches of weird questions.
Well, I think what lawmakers need to really understand before those sessions is what is the danger of allowing 18 wheelers and vehicles of that size to be out on the road. um, the more limitations we place on the individual's ability to seek redress when one of them is negligent and one of them causes injury, really creates a unfairness for the individual having to fight these situations. Um, I think the problem you've got is our future. We're looking at automated trucks being on the road. They're already on the road. They're already going back and forth between. up and down the highways in Texas right now and kind of test formats and things like that. But we're only going to see more and more of that. And when you start putting automated trucks on the road and we start seeing more and more of these kind of vehicles on the highway, you're going to see a lot of crashes and things like that. And people have to have a way to keep the companies in check to make sure that those companies are going to do everything they can to make them safe, whether they have a driver behind the wheel or whether they do not have a driver behind the wheel.
It seems like such a crazy notion. So your boards, this one's, I think, kind of unusual. You're board certified in trial law and you run your firm's online marketing.
Correct.
Which one did you learn the hard way?
Well, definitely learned the marketing the hard way. Obviously went to school to be a lawyer and never dreamed when I was in law school I was going to one day be a marketer. But I happened to be around at the time that internet marketing became a thing. Remember in the early days when we started, we didn't have the internet to look at. We actually researched the law in libraries using library books. And then all of a sudden, the internet comes out in the early 2000s. You started having browsers that everyone was using. And next thing you know, you had Google search. And as soon as it did, I took one look at that and went, this is the future of bringing in business for us. Somebody's got to learn it. And me being the young guy, as soon as you open mouth and say somebody's going to learn it, they say, great, we appreciate you volunteering. So that's how I learned it.
So I thought this one was interesting. You wrote a piece about catching an advertising scam with call tracking. Was that actually at your firm?
Yes, it was. It was.
And so what was it that tipped you off that this was going on, and what were the insights of catching that firm or that company that was doing this?
So early on, when we were really starting to learn to do internet marketing and doing a lot of this stuff, um, one of the big things was obviously trying to, you were able to track your marketing so much better using different tools and things like that. And so we had brought in a tool, our law firm management software at the time was Clio, and Clio had a function in it that allowed you to basically track through using CallRail and Clio, you could track your phone calls basically when they came in, how long they came in, what number they came in on, and you could assign a number for it, which obviously you still can do all these things. You just do it much better now. But the basic system that we had allowed me to track that information. And one day I was looking at this particular ad that we had run on a radio channel, and I went, wow, we get a lot of calls on this. So the old way of calculating the value of a marketing tool was you looked at it and went, well, this tracking phone number shows we got 50 calls a month and we paid X a month for that. So the value is $100 a call or whatever it is. And you did simple math to figure out what the leads cost, because all you could track was leads, not cases, most accurately. Well, when we had Clio, we suddenly could track every single call. And I started noticing that this one particular call number was getting about 60 calls a week. And then I started looking in detail and realized they were all coming in between about the hours of midnight and 3 a.m. And they were all coming from California, which seemed really odd considering we were a law firm in Texas and the phone number was for a Texas radio station. So when I looked at it and I started looking at these numbers, I realized then that they were lasting only a few seconds. And so I picked up the phone one day after hours and called for a few seconds, called it at one of those times. And what I realized was happening was the call was going to an answering machine at the time, because this was before we had full after hours answering services and everything else. And it was going to an answering machine. And just before the recording time would beep, they would hang up to make sure they didn't leave any record of their phone call at what hour it called. And so when I went back to the company and said, there's a really weird thing going on here, and they of course denied having any knowledge of it. And so what I did was I said, well, let me give you a different phone number. And I gave them a different phone number to run in their ad, right? And suddenly we were only getting 1 or 2 calls a month versus 60 a week. But what was really more telling is I didn't turn off the original phone number. And if the original phone number was getting those calls from some other posting somewhere or some other source, they should have kept coming through. Well, guess what? They didn't. They all stopped too. So somebody,
Yeah.
same time, turned those off.
So
And
what was the upshot of it? I mean, did you have some sort of restitution that you, or did you just wash your hands of it and say, you guys are crooks, I'm moving on?
yeah, at that time we just shut down that advertising venue and decided, all right, that's not an effective way to advertise, and we moved on.
So you published an article asking whether lawyers should hire search engine marketing companies at all. Where'd you land on that?
Well, I think you have to. I think you have to be extremely careful, though, which ones you trust with your marketing and what you allow them to do.
So okay, so that is a legitimate answer. So, what do you think most legal marketers get wrong about personal injury clients specifically?
Legal marketers make a million mistakes. The things they get most often wrong is simply they don't follow the advertising ethics rules that lawyers are required to follow, because each state has its own. And most marketers, a lawyer is just another client, so they aren't familiar with their separate rules. They don't realize things like you can't do puffing as a lawyer. You can't say I'm the best lawyer in Texas because you can't document that you are. and uh, and so those little nuances will get you in trouble with a state bar. And I see more often than not, I see an ad get posted, and I just think they didn't bother to get that one approved by the state bar. and uh and I see it all the time. You see them get in trouble for it.
So, if a young lawyer has zero budget and needs cases, and you were advising them, what would you tell them? What's the first thing they need to do?
Assuming a young lawyer is kind of starting out on his own and is looking for ways to get his own business and his own cases, there's different things you can do. You can join your state bar association. Usually with, like, if you're in the particular field, there'll be an organization or association you can join. Like in Houston, there's the Houston Trial Lawyers Association. Of course, there's Texas Trial Lawyers Association. Get to know people from there. Get to know that. Contact your state bar about getting on the free referral list from the Texas State Bar or whatever bar you happen to be a part of. Those are good ways. But at the end of the day, I mean, get your name out to your friends, your family, your people who know you, your pastor, your hairdresser, anybody who knows you and has talked to you and made good friends with you, because at the end of the day, people want somebody they can trust. And a recommendation from a friend goes a lot further than a billboard or a TV ad.
Yeah. So I'm going to ask you about the an article you wrote on July 5th, 3 weeks ago. So you wrote that Google AI can rewrite a lawyer's ad without the lawyer ever seeing it. Why is that a bigger problem in Texas than most people realize? And explain that what you meant there.
Um, could you repeat the question for me?
So it says, or my research says, and I could have this paraphrased incorrectly. You wrote that Google's AI can rewrite a lawyer's ad without the lawyer ever seeing it. So in other words, when you was that not in the article?
Oh, I know what you're talking about. Sorry. You're talking from a marketing perspective. So
Yeah, from a marketing perspective. So like you write an ad, you hand it over to Google, and you think you're doing one thing, and suddenly it's something else.
yeah, so in Google's their pay-per-click advertising and their various types of marketing, your paid ad marketing in Google, um, they have a platform where you can go in and you can just say, here's a bunch of photographs and here's the areas of law that we handle. And their AI basically creates the ad for you, and it serves up an ad to a prospective client based on what it thinks that client's likely to respond to. So it may take a piece of information and go, you are, a personal injury lawyer. This person searched for best personal injury lawyer. So the ad I'm going to show them is going to say, Paul Cannon, best personal injury lawyer. And that you can't do in Texas advertising marketing, under Texas advertising marketing rules, you can't call yourself the best in an advertisement. Now you could say, I won the best lawyer according to this particular newspaper's poll, as long as it's true, but you can't just say I'm the best lawyer without something to back it up or something to justify it, or some basis for it. Google's AI does not necessarily, or not just Google, I don't want to pick on just them, but any kind of a marketing AI may not be aware of that. Doesn't necessarily have to take into account all those rules when it's writing your ad. And so it may just serve up what it thinks is going to sell you, not necessarily what complies with your state bar's rules.
That's kind of interesting. So you get in trouble unbeknownst to you. So you argued a contingency fee lawyer billing a client for an AI tool is hard to justify. Can you talk about that? Because I
Sure.
agree, it is hard to justify.
Well, I wrote it in the context of dealing with particularly like AI tools that draft your demand letter for you, or do part of your work for you.
Mhm.
A lot of these companies, when they're selling the product to lawyers, they come in and they say, "Hey, the great thing about this is you pay $500 or whatever their charge is per case. For each case, it does all the work for you on, but you can bill that directly back to your client." Now, if I'm an hourly rate lawyer and that and I'm billing my client $500 and it saved me 4 hours that would have cost my client $200 an hour, that's a great thing for my client because I'm saving them money. And it makes sense that I bill them that instead of billing them twice that much for my time. But if I'm a contingency fee lawyer, which I am, and my client pays me a third or 40% or whatever the percentage structure is in my contract, let's say they're paying me a third on the contract, they're paying me that no matter how much work I do. So if I do a ton of work or a little work, it doesn't matter if the AI tool saves me time or not, because it doesn't save them any money. It just saves me time. My time is a flat build rate basically under a contingency fee schedule, and therefore for me to turn around and bill my client for something that saved me time and then bill them for my time on top of it is basically, in my opinion, it's almost like double billing the client. And I think it really runs, to me, it runs into a high ethical quandary there of whether or not you can really justify that.
So there's a database with over 1,000 instances of lawyers filing fake AI generated citations. It's not intentional, but why does this keep happening after the first round of sanctions? Aren't these, it seems so like with so many people caught already, why is it still continuing to happen?
You know, I can ask that question a million different ways. Let me answer the question this way, though. I will tell you something interesting. We do a scholarship competition every year, and we get literally hundreds of entries. One of them, the requirements of the entry is that the students write an essay that says, basically talks about why it's important to do pro bono work as one of our competitions. There's others that have different, the importance of Christianity in business and that sort of thing. So we have uh, different requirements, but I'm always amazed because over half the entries we get will be AI generated. We'll run them through the AI checker, and sure enough, it pops up as AI generated. I think people have just become kind of lazy when it comes to AI, and the problem is if that level of person is doing that to get into school, then what is the school producing when that same person comes out of the other end? They're probably doing the same bad habits when they come out the other end, and they're using. I think it's a lot of it comes down to law clerks and people who aren't being properly overseen and monitored and tracked, get tired or get lazy or get look for a shortcut, and they create something, and the senior attorney looks at it and reads it and goes, "Oh, this looks great," and doesn't bother to check those citations because he assumes his associate did that already. And it's the laziness and the passing the buck, I think, that's resulting in a lot of that.
So there are a lot of AI tools that are designed for attorneys and are designed to work around that, using various mechanisms. So in your firm, I think almost every firm that I talk to uses some sort of AI tool in one way or another. Um, do you guys use any AI within your firm, and how does that work?
Well, as of right now, we do not. We have analyzed a lot of it. I've actually done consulting for a lot of AI companies developing AI for lawyers. I've
Hmm.
even looked at intake software, where an AI agent answers the phone and deals with the client and addresses a lot of the stuff. And I found that was never personal enough that I wanted it handling my clients. But I've looked at a lot of the other AI intake stuff. And I think at the end of the day, there are many good uses for AI stuff. You can AI, if you have like really high voluminous records, it can summarize records really quickly for you. You can use it, and some of my litigation partner, Chris Fletcher, may use some of that in just kind of summarizing the medical records and stuff. But we don't use it to create anything that we're going to put out either to the public or to the other side, because to us, that summarization that it's doing, that's how I review the records and really get in deep and understand the file. That's how I educate myself on the full degree of what's going on. And if I'm relying on AI to do it, it may not find all the things that I think are important. It may not prioritize when I look at something and go, wait a minute, that gap right there, there's something else going on that caused that. I need to go do more deep dive. It may just give me a date and move on. And so I just don't trust it at this point enough to rely on it heavily like that.
Yep, it keeps getting better, but I use it quite a bit, and it's still frustrating as it's frustrating, and I sometimes will end up swearing at my computer and the AI engine because the output is like, I just told you one thing and you're telling me this. How can that be? You're supposed to keep track of all this stuff, and yet it can be really frustrating. So okay, so walk me through the case where police blamed your client and you still recovered 1.26 million.
Um,
Is is this ringing a bell?
I'm I'm trying to remember which case that would be. Is that do you remember if that was a trucking case in particular?
I just have a note here about that. We can move on to something else. So, um, a dog bite case where a neighbor's warning cracked it open. Does that sound familiar? I'm probably digging through all your old cases, and then I'm asking you
35
something
years
from
of
years
case law.
ago. So, and I'm
Um,
not being fair here.
so backing up, the 1.2 million, I believe, was a trucking accident case you're referring to, where an 18 wheeler was driving down a country road when it swerved across the middle lane, and the pull of the air basically pulled our client's vehicle right into the side of it, causing some pretty serious injuries. The policeman wrote it up as we crossed the center line. And what we ended up doing was we ended up getting a accident reconstructionist to come out there and reevaluate it and look at it. And they said, no, you're dealing with two objects that are such a vast different size, and they're both traveling at high speeds on a farm to market type road going opposite directions. The wind tunnel that was basically created and the wind suction between the two vehicles is what caused the client to be pulled over, not that the client, you know, was was actually driving erratically or anything like that. And as a result of that, the facts we were able to pan out and show that the investigating officer in that case did not take into account the effects of that and just basically didn't have the reconstruction training in order to understand the difference.
Well, that's an interesting one. Um, so, what's the largest settlement you've ever gotten for a family, and what did it change for them?
Um, a lot of those are confidential.
Yeah.
um,
So if
the
you can't
largest
say,
one,
that's
the
okay.
largest one that we've ever gotten that I know of off the top of my head was an 11, or it was 11.4, 11.2 million dollar, 11.9. It was, I think it may have been $11.9 million settlement, for a man who was electrocuted when he was in the back of a bucket truck and was lifted up into a power line, caused very severe burns all over his entire body. And he ultimately, I mean, the funds basically were required because he required long-term care and just in order to survive. He had lived through the event, was very badly injured. Um, it's sometimes it's not even the money. I've seen a lot of clients who ultimately were able to put their lives back together and get back on their feet in that kind of situation when they were not able to work because of an injury they sustained and didn't have the ability to go forward. So, but I would say that one was definitely something where that individual was in a very bad situation of need and we were able to help him a lot.
So how do you handle that when you have like, for lack of a better description, vicarious trauma? Because something like that, I would think would traumatically affect you as well.
Yeah, every client's life, you get to know them really well when you work with them for a couple of years, and in these cases, and over time, you get to know them inside and out. You get to know what they're like, and without a doubt, I mean, there's a lot of lawyers that wind up needing counseling in our care and that sort of thing, and you really just have to kind of learn to count your blessings, learn how to take time for yourself, spend time with your family and really appreciate what you've got and what you've been through. And I mean, the ability to get out there and help those clients is really what keeps you motivated and keeps you moving on, because those people need help, and they don't have anywhere to turn. They don't know what to do. And, we've been blessed with the training and the skills that we have in order to be able to help people like that. And so, it's kind of our calling to do it at this point. It doesn't matter who you are, as far as what you believe as a lawyer. That's what you were gifted with by going to law school. So
So I think this one here is interesting. You host, and tell me if I've got this right. You host a podcast interviewing local mission leaders, promoting their work instead of your own. Is that accurate?
that is accurate.
And what did hosting that show teach you that practicing law, didn't?
Well, we started when I took over as managing partner. I kind of went, I had kind of had this years ago situation where I had been a missions coordinator for a Bible study class, and I was very frustrated because there was nowhere you could go and just learn about local missions and figure out where to volunteer. And that was my job, was getting our class places to volunteer. So fast forward 30 years down the road, I've become managing partner of this firm, and it had always been something in the back of my mind. There needs to be this website. There needs to be this website. And it was kind of one of those God moments where something where he slapped me in the head and said, "Look, I gave you a website you're now in charge of. You're in charge of all the marketing and everything else. You got complete control of that. I forced you to learn to do Zoom videos and do recordings because of COVID, forcing you to learn to do that for hearings. What are you waiting for?" And so that's kind of what motivated me to do it and get involved. And it was just kind of that epiphany I had of, I've got every obstacle has been lifted out of the way, and I started doing it. And I've been amazed at the people I've met, from everything from human trafficking missions to food pantries to various mental disabilities and intellectual disabilities and physical disabilities. There's so many organizations in the Houston area alone that and some of them are just people. I got one, there's a student, it's called, there's a young lady, she started an organization called Young and Old United, where she literally just encourages other students to go out and visit elderly people who can't get out of their house, who need company. And she's got 400 students statewide right now doing that already. She's grown it into that. She's a high school student. I mean, it blows me away, the spirit that some people have to help and to get involved in this kind of stuff. And just seeing that, I mean, part of that is a huge uplift to me spiritually and just emotionally, to see people getting together and coming together and caring about each other. You don't always see that in the law, especially when you're up there fighting against defense lawyers and defendants and things like that.
So I have more questions, but we're running out of time. So if somebody's listening and they think, this Paul Cannon, he sounds like my kind of guy, and I have a personal injury claim or some situation similar that I think you could help on. What's the best way to get in touch with you? What's your firm's name?
Simmons and Fletcher is the law firm.
And what's the best way to find you guys?
You can find us on the internet at simmonsandfletcher.com. Call us at 713-932-0777. And you can learn more about my missions work at Meet Houston Missions. Just Google Meet Houston Missions. It's actually a page on the Simmons and Fletcher website that we've dedicated just to presenting local missions. There's about 30, 35 or so missions on there.
Very cool. I enjoyed it very much. Thanks for coming on the show. Hang with me here just a second, Paul.
All righty. Thank you.